Hello and good morning, everybody. My name is Dara Hallinan from FITS Karlsruhe. I'm moderating the panel. Thank you for coming. It's really nice to see you here, despite the fact that it is 8:45 on a Friday morning and the party was last night. But I think for those of you who managed to make the trip, it will be a worthwhile experience, because this is one of the, conceptually at least, most interesting panels at this year's CPDP. So, the use of AI systems raises a number of issues and challenges for the construction of legal systems. So, for example, how can a legal system be optimally constructed in relation to AI systems, given the fact that AI systems raise challenges and issues that seem to manifest and come to their conclusion outside the usual tracks and fora of human communication? How can a legal system be optimally constructed, given that AI systems raise challenges and issues that seem to manifest and come to their conclusion outside the normal sphere we would associate with human volition and intentionality? Now, one of the most interesting approaches that has been suggested in response to these challenges is the attribution of some kind of legal personality to AI systems. So with this question in mind, we've assembled a stellar set of panelists to hammer out the promises and pitfalls of this proposition. And they are as follows. To my left is Giovanni Sartor, professor at the European University Institute; Paul Nemitz, principal advisor at DG Just; Vangelis Papakonstantinou, professor at the Freie Universität Brüssel; and we are waiting for Daniel Bossier, who is a professor at the French National Center for Scientific Research. So with this short introduction out of the way, I'm very happy to hand over to Giovanni.
Okay, thank you very much. I have some slides. Are they already there? Yes, I have some slides. So the purpose of my presentation is to give a very quick view of what it means to be a person in the law. Let us move to the next slide, and whether, on this basis, to determine whether it makes sense to, and what are the problems in giving personality to AI system. So first, under what condition something is viewed as a person by a legal system? What does it mean to be a person? And then, under what condition should we grant a personality? In general terms, and then we focus on AI systems. Can we move on? So, the idea of a legal person goes back in the ancient times, from the Gaius Institute. Hans Kelsen, the leading legal theorist of the last century, had the idea that this notion had to be deconstructed. Persons were not individuals. To be a person just means to have legal obligation and subjective rights. Personality is not something distinct by what a person is, but it's just a role that is attributed to a person by a legal system. Can we move on? Okay, so the role consists in being the addressee of obligation and rights by that legal system. This role can be conferred implicitly. Assume that you have a norm that says that robots are prohibited from causing harm to people. From this point in time, robots will become persons, but only with regard to this norm. This role can also be conferred explicitly. Robots or AI systems are legal persons under civil law. Assume that this rule was enacted. What would this mean? Let us move to the next slide. For instance, assume that Asimov's famous laws were enacted as legal prescription. From that point in time, robot would be legal persons only with regard to these 3 or 4 principles established by Asimov. Can we move on? Okay. But then we have also a thicker notion of personality. Being a person means to have the package of rights and duties that apply to a human being. So if Asimov laws were enacted, robots would have a thin personality. They would be the addressees of a small set of norms, but they will not have the thick notion of personality, the package of rights and obligations that are attributed to human beings. But what is the conceptual role of the notion of personality? Let us move on, and here I would like to refer to another famous legal theorist, maybe the number 2 or number 3 of the legal theorists of the last century, which is the Danish Alf Ross. And Alf Ross asked himself, what is the purpose of legal concepts such as citizenship, personality, property, and so on? His idea was that the role of this concept is to simplify the exposition of legal norms. So imagine that there was a tribe, and they had their rules according to which under certain conditions, a person was viewed as bad, had to be parified, and was prohibited for participating in certain activities. And there were multiple conditions under which this would happen. At a certain point in the tribe, they invent a legal concept, the concept of being a tutu. Okay, thanks. Being a tutu, and from that point on, their legal regulation can be expressed in a much more compact way. From the initial condition follows being a tutu, and being a tutu means that you have the set of legal effects that were linked previously to each one of the antecedent conditions, such as eating of the chief's food. We may say that the same happens also to a person. You may imagine that you have a legal system according to which, if you are a human, the legal system says that if you are a human, then you have the right to acquire property, you are forbidden from harming others, you can make contracts, but also if you are a company, you have the right to acquire property, you are forbidden from harming others, and you can make contracts. At a certain point, we use the concept of a person, and the package of rights and duties that were previously connected to being a human being, now they are connected to being a person, and we may also say that also companies are persons. And then the issue is, are AI systems also persons? If we make this description, this means that the package of rights and duties that are associated to human beings will also be associated to AI systems. Personality is just a label at this point, that plays this role in the legal system, but is an important one. Is a role, a property that the legal system attributes to certain entities, and that is attributed by the legal system. The concept of a role may be characterized in this way by some ontologists, but I will not go into that. So, personality from this perspective is not a right, but it is the right to have rights, to use the famous expression by Hannah Arendt. By depriving people, human beings, of personality, as it happened in unfortunate times, these people were deprived of the possibility of, were no longer seen as addressees of legal norms, had no right nor duties. So being labeled as person is a key aspect of legal system. And being deprived of legal personality means being deprived of the right to have rights. So the issue, should we give to AI systems this kind of label? Should we label them as persons? Okay, I can skip this. We may also have different personalities. We may say that humans have a personality for fundamental rights. I forgot some arrows. But they have also a personality for criminal law, and they have also a personality for private law. Companies have a personality for private law, maybe also for criminal law. AI system, they have a personality for, may have a personality for private law, which means they can make contract, they must compensate her. Maybe, maybe not, we want to grant them also personality for criminal law, and probably it doesn't make sense to grant them a personality for fundamental rights. But what does it mean to be a person? Again, it means to have a right, obligation, and powers, a certain package of this kind of entitlement and obligations. Why should we grant a legal personality to AI? The key issue, I think, is there are two key issues. Do they have the cognitive capacities that are needed to comply, to respond to obligations? Are they able to respond to norm? And do they have the ability to use legal powers? If AI systems don't have these capacities, then it doesn't make sense to confer to them, I believe, legal personality. If they have, or if they will have, then the issue arises, and then it becomes an issue for political choices. Animals, it wouldn't make sense to give legal personality to animals because they don't have the capacities that are required to be addressees of legal norms. And then also linking myself to the recent paper by Vagelis and Paul De Hert, can we assimilate the attribution of legal personality to companies and the attribution of legal personality to AI system? I think that there is an important distinction, because the attribution of legal personality to company is, again, this is again Hans Kelsen when he was a young officer of the Austrian army. Attributing legal personality to companies is an issue of attribution. Certain human action, or even human state of mind, as an intention, are attributed to the company, or certain harmful action, depends. So the capacity to act, the cognitive capacities are not at stake. While they are at stake in the case of artificial entities. So it is a problem of agency, of competence, not so much cognitive competence, not so much a problem of attribution. So I think the two issues should be kept separate. And I leave, and then there is a problem of political opportunity. Do we want to grant a legal personality to artificial systems? And here I stop, and I give the floor to my colleagues. Thank you very much for your attention.
Thank you very much. I thought this was an excellent introduction to the subject. In the Commission earlier this year, I tried to have a discussion about the meta concept of legal person, and we didn't have it, but you gave it a little bit to us. The legal person is traditionally in, let's say, continental legal doctrine seen as a way to bring capital, to unite capital from different sources, and to unite humans for a common cause. And it is, in a certain way, a legal fiction, because the legal person is attributed by secondary law to a certain construction where capital and humans come together for a common cause. And then the law says, and now this is a legal person. Which indeed has certain limitations. For example, the question, as you said already, whether a legal person can avail itself of fundamental rights is in dispute and answered in different legal systems in a different way, and also in relation to different fundamental rights. There are many fundamental rights which legal persons probably cannot avail themselves, and there is actually also jurisprudence on this. And also for criminal law, it's a very interesting debate in our member states. Can there be at all criminal law applicable to the legal person as such? We do have in EU law certain directives which oblige member states to criminalize the behavior of legal persons in certain contexts, for example, in the framework decision on hate speech and incitement to violence. But this has not happened in some member states because they have a real difficulty with making norms of criminal law for legal persons. So I would say the starting point is therefore that the concept of a legal person is a complex one, a differentiated one, and before the Commission would be seriously considering to participate in any way in this, let's say, debate, the question has to be answered: what problem are we solving by giving to AI a legal personality, and what purpose would be served? And there, the last slide, of course, is also very instructive, because behind the technology, even a technology which evolves and learns, are legal persons or natural persons, and the actions of robots or AI will normally be attributed to those who have developed the technology or make money with it and put it on the market. The philosopher Metzinger, who was member of the AI high-level group, also pointed out that if ever AI would be developed to have traits which may justify to grant them fundamental rights. You know, let's imagine an AI which can feel pain and sorrow. Then, of course, immediately the question would be, can we treat this AI still just as a thing, as an object? Do we have to attribute to such an artifact the rights of protection against torture, for example? And Metzinger said, and I think this is a very important point, if ever this would be the case, this would be a huge innovation obstacle. Because if you cannot treat technology as a thing anymore, immediately the object nature of the technology is something you cannot just freely manipulate anymore, you cannot just change it and move on in innovation. So he actually says, for this reason alone, we should have, this was one of his red lines, we should have a red line which says it must be forbidden to try to develop AI which develops human-like feelings. So I therefore would say, before we seriously go into this direction of even, starting to write, let's say, as a body of initiative of law in the European Union on this, a number of questions must be answered. Which problem are we solving? I'm not convinced we are solving a problem which we can't solve in the usual way, by granting a legal personality to AI, because the last slide was pretty clear. I would share this also. One can attribute responsibilities and liabilities to the legal or natural person which creates the technology and which runs it. And even with the problem that the AI continues to learn, well, that is also nothing new in law, that we have a responsibility which continues even if let's say circumstances change or matters develop. So I think the problem definition is not clear. Second, if we do this, what does it mean for innovation? And are there actually elements of this technology which justify it? And the third, and there I was a little bit inspired by our moderator in the beginning, it is really a question whether the law has to change itself and fit to the technology, as you started the panel today, and you said it 2 or 3 times, or whether we should not continue to live in a world where the technology developers and the technology as such also has to fit to our constitutional settlement. I think this is actually one of the key questions of this day when we think about AI and when we think of all the big digital movements, when we think of the colonialization of our life through technology. In the end, the question is, as Shoshana Zuboff said, who decides, and who decides who decides? And so I would say in this struggle between technology, markets, and democracy rules through law, in the end, it is the technology which must comply with the laws, and not the laws must comply with the technology. So also these ideas that we can replace laws more and more by technical systems and artifacts which contain the rules, which make the decisions for us. I think all these things, apart from the fact that Stuart Russell, one of the eminent AI developers and professors, says that AI will never be able to implement principles. And therefore, that's, of course, one of the great abilities of humans, to live by principles and to be able to concretize principles. And this would be, for me, a key reason never even to come close to thinking we give a personality to these artifacts, because, you know, they cannot live by the principles of law, and much of our law is principles. So apart from this problem of fact, that this technology is just not able to live by law because it cannot implement principles, I think behind this debate, in the end, is a question of power relationships, which comes down to the question, does democracy rule or does technology rule? So it's true that there is no legal obstacle, that was my understanding of your presentation, Professor, to the legislator attributing. There's a question of political opportunity to attribute legal personality to AI, and some of those who push for it have a clear interest to shield themselves from liability. You know, the classic idea that every self-driving car should have its own legal person. Well, you know, I mean, that would be great for the you know, the product liability of the car industry, because they would be getting rid of the cumulative risk of these cars doing something wrong. So we always have to ask, you know, who does it serve? What problem does it solve? And I would say in this relationship between democracy, law on one hand, and technology and the markets on the other, in considering the political opportunity, we are not solving any problem with doing it. We are doing risk attributions, if we would go down this way, which are not appropriate in our society. And we are shifting the balance in our society between, you know, is technology ruling and is the law adjusting itself in a very fundamental thing to technology, rather than ensuring that this technology adjusts itself to the law and works to the basic principle that nothing which is illegal for a human can be legal for a machine. I don't need a legal personality for AI to be able to enforce, in quotation marks, this principle through liability rules and through the existing legal system. So that's my take on this. Also, the working group of the Commission, which has published a report on civil liability, has not gone down this road of looking at AI as a legal person, but basically looked at existing doctrine on how to attribute risks, technology-related risks in law to the different actors which have responsibility for this technology. So to conclude, I would say also, if I understand Hannah Arendt correctly, being a legal person is something which has to do something with a human. It's either a natural person or a group of natural persons which together form a legal person. And I would say, although there's no obstacle in secondary law which would make it illegal for the legislator to create AI as a legal person, there is no good argument of opportunity to do so. Thank you very much.
Thank you. It's my turn? Okay. Thank you. I would like to invoke two pictures today. One goes back in the 60s, and one is fairly recent from last week. So going back to the 60s, We have two groups of colleagues, of legal scholars, legislators, legal academics, and one group had, and each one of them had to solve a new problem. The first group had to solve how to treat software, how best to protect software, because back in the 60s, it was when software emerged from academic laboratories and entered the mainstream. So that group of colleagues decided that we should not develop anything new, that what we already had back then, namely copyright, is enough to protect software. Software can be accommodated by what was at hand. We could switch and turn and manipulate a system developed for the protection of music and books, and somehow struggle to make it fit so as not to develop anything new. And then, as a consequence, software still today is protected as a literary work, similar to a book. So we have the most important asset on earth today protected in the same way as a book, because these persons back in the 60s decided that no new legal system was needed to protect software. At the same time, in the 60s, in Germany, there was another group that had another new challenge coming, the automated processing of personal data. Because back in the 60s, it was when computers exited the laboratories and then started entering the public administration back at that time, who could only afford such technical monsters. And that group decided to develop something new, a new law. So they drafted something out of nothing and they did not try to accommodate automated personal data processing through, for example, what was already at hand in civil law, the protection of the image of the person, or the protection of personality, or what was already at hand in general constitutional law, what was already at hand in human rights. No, they decided that it was something new, and new rules had to be developed from scratch to accommodate that new thing. And now, if we fast forward today, the first group that decided to protect software through copyright has, to me, completely and utterly failed, because each one of us knows software patents, so it is an immediate breach of the system of copyright. Copyright can evidently not protect software. Software does not fit well into the copyright regime, and the European Commission itself indirectly admitted failure, not its own failure, but failure of the legal system, of course, because back in the 90s, it developed a new database, right? Sui generis, which means new, extraordinary, nothing, right, to protect databases. So the first group, to me, failed. It tried to make do with what was at hand and protect software, and 50, 60 years down the road, there is a problem at hand. What happened to the other group that developed something new? That was developed back in the 60s in Germany, has today developed into the GDPR. So it is the main reason why we are all here. And it has developed into a new field of law. It has developed into Article 16 of the treaty. It has developed into data protection, personal data protection that we all know. So you see the difference and the impact between these two groups. So that was the first image that I'd like to invoke. The second image is from last week. So last week, the CEO of Google was here in Brussels, and he made a donation to a local organization, and then he made a statement, a rare statement, on the need to regulate AI. And the statement went more or less like this: we do not have any ideas, we need to regulate it, I do not know how, there are some good ideas in the GDPR. So to me, that statement is a desperate statement. If the CEO of Google has no clue how to regulate AI, but still he feels that AI should be regulated, then there is no clue anywhere on what to do about AI. And then, again, the GDPR. Let's use some ideas from the GDPR. The GDPR is not a one-size-fits-all solution. It is good on its own terms, but it will not solve everything, every problem of humanity in the digital world. It will not solve bioengineering. It will not solve drones and robots. It will not solve artificial intelligence. It will not solve all new things that technology will throw at humanity. It is not the one ring to rule them all. It is a very specific human right. And if we start treating human rights as personal data to be always seen through the interface of the GDPR, then there is no need for other human rights. You can rewrite the list. Because all human rights include some personal data, the right to freedom of religion, freedom of expression, freedom of assembly, freedom of association. All of them include personal data because we are persons. So if we project the GDPR everywhere, on all things digital, and again, on all things that are thrown to us, try to get ideas from the GDPR, then we are serving not its own purposes and not the purposes of the new challenge that is ahead of us. For these reasons, I think that something new needs to be done. That AI needs to be treated differently, not by stretching and manipulating civil law that is based on Roman law, that is based on very specific assumptions on what is a person, as extended in the 18th century by the addition of the legal person. But still, the assumptions are the same. So if we still insist on using civil law for liability, and the GDPR for human rights issues, and some other field of law, copyright for property rights on AI, then we are stretching, we are making do. And lawyers, of course, are very good at doing that. If we are given a problem and we are told you have to make do with what is at hand, then we can do this. We can definitely write new provisions based on the old provisions that will somehow regulate this problem. So if a drone falls from the sky and kills somebody, then we can definitely write new rules on how drones should be regulated. That is easy to do. But this will not solve the problem, the fundamental problem, because we are still avoiding the elephant in the room, which is AI is something new. And as such, it needs new rules. So, yeah. Thank you.
So I think Danielle is just sorting out her slides. So maybe if I ask a question to the panel while we wait. So we've heard certain different perspectives on AI. It's attributing legal personality to AI, some negative, some slightly more positive. Looking at the situation objectively, Vangelis, in your paper with Paul de Heert, you mentioned certain cases around the world in which there is already something like an attribution of legal personality to AI. You also mentioned the fact that in many of the policy papers and many of the discussion fora dealing with AI and questions of AI, the idea of attribution of legal personality is already a prevalent topic. So how close are we to this entering European law, regardless of whether this is a good or bad thing, and what forces are going to play the shaping role in how legal personality for AI enters European law, if it does so at all? I open that to the whole panel. Please.
Okay. Well, I think the plea for there is something new and we've got to do something new, therefore, is one thing, and I think the Commission has very clearly shown that, yes, we're doing something new for AI. We will come up with a legislative proposal to regulate AI. But I have heard not one argument from Vangelis why this newness is such that now we have to attribute a legal person to this technology. So I think the question of how far are we away can be answered in two ways. You can ask, is legislation the only way that legal person for AI becomes an issue of European law? And that, I would say no. There's another way how it can become an issue of EU law, and I will describe this in a moment. But as far as legislation is concerned, at this time, and this may change, and I mean, I'm just a civil servant, and our politicians may see this differently eventually after the consultation on the white paper of AI, on AI regulation, which comes out on 20th of February. Let's see what the discussion brings, but I think at this stage there's no appetite whatsoever for the Commission to propose this, and I don't see also in member states any government which is very keen on this. But if other jurisdictions create legal persons for AI, then let's think this through. So we have a legal person, I don't know, in Oman, in Qatar or somewhere, yeah, which is now an AI legal person. And this legal person decides to invest in Europe in a limited liability company. Well, if you create a limited liability company in a member state, then you have all the rights of an EU legal person. And in this way, such AI legal persons may become subject to EU law. And then we have to think about, what does this mean? But for the time being, at least, even if such a legal person invests in the European Union, you still need people behind it. Because you cannot create a company in the EU without having a natural person who is in the register as the one who takes responsibility for the legal person, who is the representative, and so on. So this would only be, let's say, in the mother-daughter relationship that this could become an issue. So I think it is important for legal doctrine to think through such constellations. But as I said, my feeling is the interests, if you ask for those who are pushing for it, a few ones, the main interest is to shield against cumulated responsibility risks from this new technology. And that is really a question, do we want to give such a subsidy to the big developers of AI and allow them to shield, in limited liability persons? Would be great to split up of the risk. Or no, and I would say absolutely no. On the contrary, we need to look at the law as an instrument to provide incentives to make this technology safe in all respects, including complying with our fundamental rights, not harming democracy, and so on. And if we shield from technological risks through giving legal person, we do exactly the opposite. We give absolutely the wrong incentives. So there I'm totally with Calabresi. The cost of accidents, I can only say, everybody who wants to understand how we have to deal with technology in terms of regulating and attributing risks and responsibility, now is the time to read again Calabresi's cost of accidents to understand how we have to relate to this new technology.
Okay. So Paul has focused on the political issue, but I would like to focus instead of what it means to be a person. Why, for instance, cows are not persons? We could enact a law according to which cows are as persons under civil law. But then a cow would not be able to know what norms exist. They would not know what a sanction is. In order to be motivated by a sanction, you need to have awareness of your interests and how the sanction is going to affect your interests. Then a cow will not be able to make contracts. It will not have the capacity to be an incapable person. And I think that at the state of the art, something similar would happen also to the AI. Even if they were made a legal person, then I think without being supported by humans, they will not be able to identify norms, comply with them, comply with principles, be motivated by sanctions. But maybe in the future this will be the case. So I think we have to distinguish between the state of the art, where I think that granting legal personality to AI system, first of all, there is a cognitive and a political issue. First of all, nowadays, it doesn't make a sense from a cognitive perspective. They don't have the capacities that are needed to respond to norms and to avail themselves of norms. In the future, maybe they will have these capacities, and then the legal issue that was raised by Paul would emerge. But it seems to me that nowadays, even the legal issue is premature. The political issue is premature since Even if the AI were granted personality, they wouldn't be able to make use of it at the state of the art, from what I can see.
Thank you. All the arguments that have been used against giving legal personality to AI can exactly be used against giving legal personality to legal persons. It's exactly the same thing, and to some extent, we are opening again a dialogue that was a discussion that was opened 150 years ago, when legal persons formally, I think in the UK, got the Companies Act first got their legal personality. Again, it was liability issues. Again, it was how big companies will be protected. So all of them have been discussed by humanity. Again, they're not first-timers on the scene. What I would like to immediately do is break unequivocally and beyond any doubt the link between giving a gift to big enterprises, or the link between technology being imposed on law. I do not see it that way. To me, and again, also to reply to what is the problem that we are solving. If I buy a drone, for example, if I buy a drone and use it because I'm a photographer, and use it to professionally take pictures, and give that drone legal personality, then there is no way that the manufacturer of drone, Google or whoever else, profits from this. On the contrary, from what is happening today, Google is profiting, because if the drone malfunctions, or if I make and falls off the sky and kill somebody, then who is responsible? Today, Google can't be held responsible. So we should, if we draw accountability to the level of the handler of, and again, it's legal persons, in legal persons, it is individuals that are behind these legal persons. So they are accountable for their actions. Of course, it is fiction, and the only suggestion is to add some more fiction to what already is fictitious today in law.
I'm quite keen to close this question discussion and pass the floor back to Danielle for her presentation.
Yes, good morning. I'm sorry to be late. I come from France, and you know it's not easy to travel currently. So, it's possible to have a PowerPoint? No, I don't. Please? Okay. So. I am Danielle Boursier, and I work in AI and law, and of course I'm very interested in this aspect of the problem currently. So we work on in my laboratory in University of Paris 2. We have already worked on expert system. We create expert system, and we use also a neural network in the field of judgment. And so we have a very deep experience of how does it work, and what are the dangers and the advantages of all these tools, of course. A very important principle, it's not the topic today, but it's a principle of transparency. And more and more we are sure that from the public law perspective, legal algorithmic decision is totally illegal. And all the jurisprudence of le Conseil d'État is totally on the contrary of this type of decision. I cannot develop, but it's very clear that the regime of administrative decision needs a lot of conditions, external to the act or internal, substantial, and algorithmic decision. It's a very important problem, because it's totally illegal, not because it is a technical tool, but because the domain is totally against a decision without motivation. A legal decision is not only the result, a legal decision is a motivation, all the deliberation inside the process of decision making. And it's totally opaque, you know, and it's not, at the moment, it's not possible to open the black box of the legal decision. So, a lot of questions also about ethical, but I continue. So, robotic course, decision. So, before we work on the question of virtual person, it was a long time ago, 20 years, but it was a solution to create a virtual person as a double of or a portfolio of our personality projected on the internet. But it's not exactly also the same problem. But at this, when we work on this virtual digital person, it was also a proposal of the Conseil d'État. The question was, I was on the internet and I say, what is the relationship between natural and artificial person? And if virtual agents can act on our behalf, what will be their real legal capacity? The very important question, I think, in this one is if they act on our behalf. That is a question, and it's why the question today is very important. For example, if, but I come back to that. So, legal personality, sorry, it is in French. It means that if it is a legal personhood, this person can have a patrimony. It can be the author of legal acts, for example, election. Not only, it's a question of responsibility, it's not the only question. There are a lot of things about that. It can be protected, and it can be, of course, responsible. So, but always we talk about decision or about artificial personhood for individual person. But what about a judge, a digital judge? Because sometimes it can be broken or something like that. Who would be responsible of a artificial judge? It's another question that to know if it is a vehicle, automatic vehicle or so on. So this question has not been studied at the moment. You know, a dysfunction in institution due to artificial tech. Okay, so this is another question. So I place the question of artificial agent, artificial personhood in a context. More and more, the personhood is attributed to non-human entities, not only tech personhood. So I think it's a larger problem. Don't be only interested by the numerical aspect of our legal question, but we have to think about a larger view of why it is a problem, not only because of technology. So that is, to me, a point. And for example, we are working on a book at the moment, and the question is, can streams, landscape, woods get a personhood? Not only robot. And why? And we have a question, why? Because these new entities needs protection, and actually the answer, the legal answer, is sometimes not enough large or broad. Okay, this is why. It's not an intellectual problem, it's not a theoretical problem, it's not a metaphysical problem. It is a functional problem, because law is very functional, and I think it's why I agree with you. I think it's totally, it's too in advance to to ask a question of the personhood. I am sure that when it will be the only solution to close a conflict, we will have this possibility. But I think it's not a good attitude to anticipate too much, because at the moment, I think we have enough tools, responsibility for children, for employees, for dangerous tools, products. A lot of regimes can be used to solve the problem of responsibility and so on. But sometimes, why at the moment a lot of judges in New Zealand, for example, in Australia, choose to imply and to insert personhood in the courts, it's because it was the only solution to protect some rights. And I think it's also a kind of communication aspect also. But anyway, another question to me is, what is an AI? Is it an individual human-like tech, like the robot now, I'm sure you know? Is it a collective AI? The web is an AI in a sense. So it's another aspect. Is it an intelligent agent like a chatbot? And I think the problem is different. And Joël de René, a long time ago, talked about a symbiont, a mix between a hybrid artificial person. So, what finality? For what use? All these questions must be asked also in the framework of our discussion. I think another question. I try to make more salient some new question, of course. Crucial distinction, because I work on legal decision making. We have to make a distinction between management systems and decision systems. It's totally absent of discussion also. Why? Management system, it's internal system in the administration, in the organization. It's just a facilitator of tasks, many tasks of administrator. Decision system and forcible application to citizen. It simulates a decision-making process is totally different to me, because decision system create a right, for example, an action. It's possible after, from this decision to act in a court, but jurisprudence also in France has decided that the decision internal to the administration, it's a decision it doesn't affect directly a citizen. They have no rights to act against this decision of management. So it's important to me. Supralegem, for example, it is a predictive algorithm. It has been it is used to provide the outcome of a dispute and so on. The tool is totally transparent, but it has been rejected by almost 90% of judges asking not to publish their name also. That is another question. Maybe you know in France it will be impossible to do studies or predictive analytics on decision because the judge now it is a law of last year. It is impossible to treat in an analytics algorithmic tool or anyway the names of the judge of decision. It will be, the name of the judge will be totally absent because the judge doesn't want, in France, maybe it's strange for researchers because we cannot do analytics now, but they decide not to be totally anonymized on the web. Okay? Yes, I was talking about extension of legal personhood and I have been told that. So you know also the selfie of a monkey and so on. So I think it's why I try to enlarge the discussion, because I think we have to also maintain a cohesion, a coherence in the progress of legal questions, okay? And why so many entities become entities with a certain, with rights or with a certain personhood? Why? Because features of empathy, psyche, emotion are more and more studied in the field of artificial intelligence. And empathy, you know, this type of affective robots and so on, now all these robots become closer and closer in our lives. That is a question, you know. I have also a distinction to do between legal personhood and subject of right. I am not sure of the translation. I will say in French, sujet de droit. I think personhood is larger. It's a categorization. It means that if you insert an element in this category, this element takes all the effects of this category. And it's a very important decision to decide that, for example, when slavery was forbidden, you know, it means that directly the slave become a citizen, you know, without, and it's a decision from the beginning, per se. If you decide to give some rights to some entities, of course, it's not so important, not so large. It's just some rights or obligation and so on. It can be considered for local, for provisional or circumstantial attributes. You know, it's not so. Maybe we will go towards this type of decision. I don't know if you know the COSA case. It is a robot, but it's also not a robot like now. It's a firm in the United States, and it's very important because this firm is considered, I have not the details of that, but I have been told that this firm can produce invention, innovations, and this firm has artificial intelligence of digital personhood. It's with 1,050 and 500 computers. It's a large place in the United States. And this, all together, they can do a lot of things, as we said, better and quicker than any kind of normal firm. So it means that this firm has been conceived as a total entity, total artificial firm. For example, this firm can hire engineers, they can repair breakdowns, they can deposit patent, they can a lot of activities and generally considered as human, okay? So I arrived at the question and I have no answer to all these questions, I'm sorry. But for some of them, to give them human-like independence and to empower them, I think it's a consequence of intention. To grant them rights of obligation to reinforce this autonomy. The question of autonomy, I think, is crucial, and it's not, you know, now it's not. I think artificial intelligence agents are not autonomous. It's true technically, and I don't know. I understand that if they are not technically autonomous, they don't have the possibility to be independent and a person, like human persons. So I think it's why it's too early to talk about all these questions. But they can need identity. They can also have a life, a birth and a death. They can also vote. They can have signature. A lot of rights and you know, can be attributed. We have to think about all these things. So Is a doctrinal step really justified, and so on? Too early, I've already said that. Their impacts are not enough significant. Sometimes, in some arena, I have the feeling that it's speculation. It's very, very interesting. We are all interested by speculation, but I'm not sure that some real impact are significant at the moment. I have said already that it exists some legal answer, regime of liabilities, children, employee animals, dangerous products, and so on. Why it exists, this question? I think it's totally legitimate to talk about that, but I think it's launched sometimes by some specialized lawyers, experts in legal tech, so they are very interested by talking about that. But judges are neither in favor of a new regime nor in favor of predicting algorithms. I said that because in France we have two experiments have been excluded after experience in the courts, as I said before. So, as I said in last year, French law bans use of analytics that calculate just future infringement is 5 years in prison for rule breakers. It's very, very serious. What consequences? I think it's not very original to say that it will create a new complexity between enforceable legal regimes. And I think the delegation, on the contrary, I think we have to think about the regime of, all the regime of delegation. Delegation is a very important institution in law, and we have to think about that, because a lot of time, a lot of situation, it's just a discussion about delegation, not about personhood, but what is included in the delegation. What specific current legal and social problem? Well, I think productivity, but productivity in a lot of domains. For example, in administration, in political institutions and so on, productivity is not really a question. I often ask, what is productivity in justice? Productivity, if it is to organize le greffe or administration, of course. We know that justice is too slow, but it has nothing to do with artificial intelligence. But productivity, it will be a better justice. What means justice in the meaning of optimization? As always we heard optimization. We need to optimize, of course, but what type of optimization do you want? I think we have not enough cases and pilots. And question 5, what condition will serve to promote the adoption of legal personality? I think we wait for a new hard case in courts that would be impossible to solve with the current legal rules, the state of art, and we will have a functional answer, not a theoretical one. What problem might follow and how could they be minimized in advance? How can we do that? I think the difficulty, and I think we said that, difficulty to retrieve the different actors. If we adopt personhood, there will arrive difficulty to retrieve the different actors implied in the chain of causality and their specific role, ownership of data, developers, trainers of big data, the trainers, it's a new profession, If you need to train non-supervised system, it means that a lot of people will choose and treat a lot of data without knowing from where. And this is a very important decision to say the trainer of big data. Ah, d'accord. Excusez-moi. OK, d'accord. But I think it's the end of what I want to do. Okay?
Wonderful.
Just this last slide, angry robot put in jail by predictive algorithms without arguments. Thank you very much.
Thank you to all the panelists for some very, very thought-provoking presentations and interim discussion. I'd love to open the floor now to anybody from the audience who might have a question for any of the panelists. Yes, you go to the...
Yeah, thank you. My name is Oskar Stein. I'm assistant professor at the University of Groningen. Thank you very much for this very interesting panel. I really enjoyed it very much. There were just 2 points, and sorry that I'm using my notes because it's a very complex topic we're talking about. So first of all, I totally agree that I think we need to take the substantive layered approach when we talk about legal personality of AI. Something that I've been a bit missing from your discussions is that on the one hand, I think it's very good that we're talking about is all persons, and especially legal persons, are the same. But on the other hand, I'm not so sure whether that's always true. When we think in the context of the European Union, that when it comes to the fundamental freedoms, that not all citizens of the European Union maybe enjoy in different kinds of situations the same kind of fundamental freedoms. When we look worldwide, how different citizenships associate different rights, especially to free movement, then I think in reality, when we look at the law, not all legal persons or that all persons that are seen as a person by the law are actually treated equal. So I think we also need to take this into account. I can imagine that if we go down that route with artificial intelligence, also that debate will emerge much more. And then there was a second thing that you, Mr. Nemitz, said, which I found very interesting. And I hope it's not too controversial, but you said that there was no obstacle in secondary European Union law to give legal personality to AI, which then in me triggered the question, why would it be up to the merits of secondary European Union law to give legal personality? Because first and foremost, legal personality comes from member states. What I also find interesting when we talk about fundamental rights and legal personalities is that when we look at different kind of member states, we have, for example, the right to freedom of expression or data protection. You have for some companies in some countries, whereas you don't have it in other countries. Or sometimes you have it also for public institutions, but sometimes you don't. So from what I've seen in the legal landscape, this whole topic is much more fragmented. And so if the European Union then decided to give legal personality to AI, I think this could potentially only be in form of a corporate form. So that is one of the questions. And then on the other hand, that provokes the question, if one member state that is supposed to be very innovation-friendly gives legal personality to AI, how do the others then deal with that? Because I don't see how the European Union could do something against it. So thank you very much.
Could I perhaps suggest that if there are any more comments from the audience, people step forward now. Otherwise, I'll open up the floor to the panelists. So, have any of the panelists got a response to the professor from Groningen?
Yeah. So, I think this was a misunderstanding. I think you are right that legal person can be, and the usual normal creation of legal persons has come from member states law. But in EU law, we have also created legal persons. The European Society, the corporation is one example. So both is possible. Now to the question, are there legal obstacles? I think in secondary law, in primary law, you always have to ask, is there a legal base? Or is there an obstacle to the law doing something? I don't see an obstacle. I don't see an obstacle in EU law. I don't see an obstacle in member states law. So you're right. A member state could create such a legal person. But then it gets more complicated. And I would draw here maybe a little bit remote, but still a parallelity to citizenship. We do have a rule which says citizenship is even written in the protocol to the treaty. Citizenship is the exclusive domain of member states. But because through EU law, citizenship of a member state attributes rights in relation to other member states, it is a matter of common interest. And we have member states who started to sell their citizenship just to make money. And I would say, well, may well be true that the treaty says citizenship is a member of member states' law, but nobody thought about the selling at the time, and selling a member's citizenship is a matter of common interest, because EU citizens get rights all across the Union, and one member state makes money with it. And I would say the same type of discussion would come up if we suddenly have a member state create legal persons where you cannot get to a responsible human anymore behind it. Because the concept of recognition of legal persons created or established in one member state having the same rights as legal persons in all other member states is based on this assumption. Like the rule that citizenship is created by member states is based on the idea that citizenship goes with sovereignty, but not with selling it for money. So, I have never thought beyond that, but we would get an interesting debate if one member state starts doing this out of economic interest to subsidize technology development, shield them from responsibility and so on. That would be thorny. I don't see the legal argument yet what we could be doing about it, but I think it would be a problem.
I would just like to point out that consider an example. Imagine that Siri, the voice answering system on the iPhone, is Estonia decides that Siri is a legal person. What is going to happen if Siri is going to be subject, as a consequence of that legal person as a package of rights and duty, is going to be subject to civil law, to criminal law possibly. So if Siri utters an insult, then Siri is going to be liable. What kind of sanction? Imprisonment? How would you imprison Siri? Or maybe a fine, but then would Siri satisfy the mens rea requirement, and has Siri sufficient reason responsiveness in order to be considered as responsible under criminal law? And what about civil law? So there is a host of problems, I think, to which we are not prepared. There is a legal issue, but there are also a host of problems to which at the state of the technology, I think we are not prepared. So maybe in the future, the things will be more meaningful. Maybe, as it was said by Daniele, it may be possible to assign specific obligations to an AI entity which is able to understand that obligation, or to view it as an object of protection, like a river. But then, being an object of protection, does it mean to be a legal person? Probably not. Yes. I think that focusing on the legal technicalities may lead us to forget that there are also some substantial technological and cognitive issues that are before those legal problems.
So if the panelists are finished responding, or Danielle, did you want to respond? Perfect. Yes, so I would be, unless the panelists have to urgently leave the stage, I would be open to another question from the audience. And if there are no further questions from the audience, would the panelists like to offer a very quick wrap-up of their understanding of the session and their position?
I think it's difficult to have final words. I'm a little disappointed because we have no question from you, because we need, I think we need all the questions emerging of this debate, because nobody has to decide a trend or a solution. So anyway, I think final words, I think we have to continue the discussion, not only in conference, but also in training, initial training at the university and so on. I think we have to develop reflection about all these questions in the training at the university. Sometimes I think university sometimes is too far from all these very new questions. And this is my first point. I think the university must integrate new questions, not at the level of PhD dissertation, but from the beginning. Numerical law must be taught and discussed from the beginning of the legal studies, political studies, sociological studies, and so on. So, okay? And I think my second point is really not to be too anticipating all these questions. Of course, it's very stimulating, but I think we have also to wait. The evolution of technology, maybe it's not enough ripe at the moment for a solution. And my third point is we have also to consider that all the questions are not only isolated in the field of digital fields, but as I tried to explain, some questions are more longitudinal, we have to think all the movement of law, not only in the field of digital law, but also environmental law, care law, and so on. So it's my final remarks. And thank you very much. And personally, I'm very ashamed not to be at the beginning of this very stimulating session.
Okay. For me, my main worry is that what Danielle predicted will happen, that we will have a big court case, we will not be able to solve it with what we have already at hand, and then we will develop something in a hurry. So I think that I understand that it is premature, but it is never too early to start thinking what it would be like and what it could be like.
But I think that what Vageli says is true. We need to start as an AI system as becoming more and more autonomous and more able to engage in planning and more able to respond to various stimuli and also sanctions. We need to consider what will happen in the future and what kind of regulations will be suitable at that point.
Thank you all for coming, and thank you to the panelists as well for what I think was a really, really fascinating discussion. And please enjoy your coffee break.